I'm Sara Bronin, and I created this Property 101 series for you to understand the basics of property and property law. Today, we are talking about the third question, using property. In another video, you learned about the different types of easements, easements appurtenant or engross, etc. In this video, we are talking about 5 ways to create easements. The first way, which I would say the easiest and most common way, is an express written grant. Generally speaking, the statute of frauds is said to apply to easements. So again, generally these have to be in writing. In addition, in creating an express easement, a court will look at the document and make sure that subsequent owners of the servient estate have notice. They'll also look to make sure that there is an intent by the original grantor that the easement runs with the land. In thinking about notice, this can be actual notice, inquiry notice, in other words, you had enough information to go inquire, or constructive notice, for example, by placing an easement on the land records. A second way to create easements is by estoppel. So you have heard this term in contract law. An easement by estoppel may arise if the grantor orally tells someone, for example, that they can drive across the grantor's property. Courts that recognize easements by estoppel will review whether the grantee relied on the oral statements that were made. Many jurisdictions, however, limit the creation of easements by estoppel because, going back to what I just said, the statute of frauds is generally thought to apply to easements, with a few exceptions that we're discussing today. But again, there is a bias in the courts against easements by estoppel. Third, there are easements by prescription. There is a whole video on these, but briefly put, an easement by prescription is a right of access which can be granted under terms similar to those of adverse possession. For example, it can be granted if the party seeking an easement or an access way can show that over a statutory period, their use or their access to property was open, adverse, under a claim of right, but without authority of law, and without the consent of the owner. So here, as we said in that video, you are not seeking possession, you're seeking not ownership rather, but use. You do not necessarily have to pay taxes or do other things that an adverse possessor might have to show or do to prove ownership. If you do get an easement by prescription, you get it perpetually. Fourth, an easement by necessity or an easement implied by necessity. So these kinds of easements occur when an owner sells a landlocked parcel to someone else, usually from some common property. So the easement is created to pass over the property that the owner retained if that's the only way to get to the landlocked property. Relatedly is the fifth way to create easements, and that is easements by implication by prior use. So prior use easements. This occurs when a parcel of land was once in single ownership and is then subdivided, similar to the last set of easements we talked about. But the particulars of this scenario are specific to the state. And generally, the prior use has to have been apparent, obvious, continuous, and permanent. In addition, the easement has to be reasonably necessary and beneficial to the enjoyment of the grantor's retained parcel. So those are the 5 ways that you can use to create easements. Some are more favored by courts than others. I will leave it there, and I'd love to hear from you through Twitter or through my website, where you can sign up to my mailing list. See you next time.